I wanted to verify that that's true, that you're unable to reach a verdict as a panel.
Correct.
Okay. And so what I'm going to do is declare a mistrial in this case.
Those are the moments Judge Christina Mims declared a mistrial in the trial of Christopher Schurr, the jury coming back deadlocked for a second time Thursday morning, leading to that mistrial. And right after the prosecution and defense teams both debriefing with reporters about what happened. And at this point, right now, joining us are two of our experts that have been here since the very beginning with us, analyzing this trial. We appreciate them both very much. We have Andrew Rodenhouse from Rodenhouse Law and Tonya Krause-Phelan from the Cooley Law School. Both of you, initial reactions now that you have had a couple of moments to sit with it. We're about 24 hours or so removed from that mistrial decision. Tell me your thoughts. What are you guys thinking about it?
I'm not surprised that there was a hung jury. As we talked throughout the trial, we thought that it would be a tough decision for the jurors to come to, and especially when that manslaughter, the lesser charge, was introduced to them for consideration. We thought that that might really increase the possibility of the jurors not able to come to a decision. So I'm not surprised that there was a mistrial.
Yeah, Andrew?
I agree. I thought that, particularly in light of the fact that we had so many conflicting experts with different testimony about what the standards are, I was not surprised that we ended up with a hung jury. I had several people asking me that over, it was my father's birthday, so he had a 75th birthday party. So happy birthday, Dad. I know you're watching. But that I had said, I was predicting that it would be a hung jury just because it was a complicated issue.
Yeah, and of course, I mean, there was so much testimony. And of course, again, I think you're right with that voluntary manslaughter charge tacked on as something they could consider at the very end. That threw another situation in there for them to ponder while they were in that deliberation room. Andrew, before we jump into some of the testimony here and the analysis of all of this, you were actually in the courthouse when this was all going down.
I was.
Yeah,
I actually have a job that I work at, and I go to court on a regular and routine basis. I'm friendly with a lot of the people who work there. And so when the verdict, or when the decision was made that they were going to have a hung jury, there was quite a bit of buzz happening in the courthouse. And so there was a number of guards that were moving in and out of the courtrooms. They were getting in place because there was a number of different supporters that were there on, supporting Schurr and supporting Patrick's family. And so they just wanted to make sure that all the law enforcement was in place. And so then we started to hear some buzz in the courthouse about the fact that there was going to be a mistrial.
Yeah, okay, interesting. So let's go right to Beckers' comments, the prosecutor. He immediately after the trial, about an hour or so, started to give public comment to some reporters in the room. He basically addressed whether he was going to retry this case. I know there were several questions about that. At this point, he's saying that he's not going to make a decision right away. He's going to consult with the Loyola family, going to consult with everybody involved, speak to the jury members about what went down. Tonya, I'm curious, what do you think he should do at this point?
Well, I'm not going to say what I think he should do,
Okay,
because that's a decision he has to make. And you correctly point out that one of the first things he's going to do is talk to the Loyola family. Under the Crime Victim Rights Act, he does need to consult with him, but it's also the right thing to do to get their input of whether they want to sit through another criminal trial, especially knowing that there's a civil case pending as well. And there's an old adage that us trial attorneys have. There's the case you prepare, the case you try, and then the case you wish you would have tried. So he's going to do some reflection on how the case went in, how things went throughout the trial, and he's going to reflect on whether or not he should proceed to trial again or whether he should consider some alternative option.
You mentioned an act that he has to do with the family. Can you explain more about that? I think that's interesting.
Yes, Michigan many years ago amended its state constitution to include the Crime Victims Rights Act, and that has many protections guaranteed to victims of crime and the families of victims of crime. And one of the things that act requires is that the prosecutor consult with the family or the victim as appropriate.
What are your thoughts on what Becker's next move should be?
Well, I think he's doing the right thing. I mean, he's taking time to actually think about what he should do. I would assume that he's consulting with his staff and his team back at the office. He is the constitutionally mandated person who decides whether or not the case moves forward. He's the chief executive officer in this county as far as law enforcement goes, and the decision is solely his. But I think he's taking time as the appropriate response, and also consulting with the family of the victims. I think he also needs to take into account whether or not this is a case that he could ever possibly prevail in. And so that would be a consideration also.
Yeah, something that he did mention is that he did get to speak briefly with some of the jury members. Of course, you guys had mentioned early on that if this does go into whatever mistrial could be happening here, they're allowed to do that after the fact. Based off of what you heard from his comments there, what do you think that he's thinking after that initial conversation with the jury?
I'm not going to speculate into the
Yeah,
mind of
I
that
think
person.
it's too hard to speculate because we don't know what the jurors told him. And as I listened to both of the press conferences yesterday, it was pretty clear that they did not, either the defense or the prosecution, have the ability to talk to all of the jurors. And I think that that might make a difference. They probably just got a snippet yesterday.
Okay, yeah, just a little teaser of what they might be talking about with them in the future. So he also mentioned in that press conference there, he was asked a question about whether he was under any public pressure to bring those charges, and if so, did he have any second thoughts about bringing those charges? And he answered no. He doesn't have second thoughts about this. He doesn't believe that there was any public pressure for him to try this case. At this point, what's your take on those comments?
I've known Mr. Becker for a number of years, and he's never struck me as a person who was going to bow to public pressure, that he would do what he thought he needed to do, right, wrong, or indifferent. If he felt the conviction to do something, then he would do it without hesitation. So he's, in my opinion, he's got principle when it comes to that.
Let's talk about the jury a little more in depth here. Borgula did offer up an indication as to which way the jury kind of swayed, saying that overwhelmingly, in his words, that this jury was going to vote for an acquittal here. But of course, we ended with the mistrial. Do you think it was smart for him to offer that up? And if so, what's kind of the strategy behind that?
Well, I think it's designed to apply some more pressure to Mr. Becker to not retry the case, because again, you have to take into account the amount of money and resources that the community is putting into this, and at the end, that's one of his factors that he has to consider, is whether or not the community can go through another trial like this, and whether or not are his odds of prevailing. And so, from that standpoint, I think that Mr. Borgula was making a strategic statement in an effort to get the public opinion on the side of the defense.
Tonya?
I agree. And coupled with some other statements he made about the legal challenges they anticipate making if Mr. Becker decides to retry the case, I think that those two things were a 1-2 punch messaging-wise, that look, we think that a lot of inappropriate evidence came into this case, and we're going to challenge that if this case is retried. So even with all of that inappropriate evidence coming in from their perspective, the jury still was overwhelmingly in favor of acquittal. So I think it really was, as Andrew said, a very strategic decision to make those comments together.
Almost sort of like a message to the prosecution in this case. With that being said, at this point, what are the paths forward for the prosecution and any potential paths for the defense if they decide to go ahead and retry the case?
Well, because the jury was unable to reach a verdict, the second-degree murder charge is still pending against Mr. Schurr. So that's in place, and that remains an open file in Kent County Circuit Court. And so if Mr. Becker decides to retry the case, they pick up with a new trial date. They don't go back to the beginning and start all over. So that's one thing to consider. But if, in fact, after talking with the jury, they decide that it's not worth going forward, or the family doesn't want to go through another criminal trial, whatever reason he might have not to retry the case, then he has to decide, do I offer some sort of plea offer, or do I dismiss the case outright?
Okay, so, and if, let's say that they go to a retrial, and they do come to a conclusion on a retrial, the defense can appeal, right? So there are several things that they talked about in an appeal, specifically some of the witnesses that we heard from in that idea of, I believe it was like a officer-created jeopardy and that testimony as well. Any indication as to how that might play out? I'm just trying to gather the situation.
I think that if Mr. Becker decides that he wants to retry the case, I think it's highly likely that the defense will file what's known as interlocutory appeal into the Court of Appeals.
Yeah, that's something he did talk about, yeah.
Yeah, challenging those witnesses, particularly the two experts, the professor and I forget his partner's name, challenging them into the Court of Appeals simply because the trial court has already ruled on it. And the trial court has said we're going to allow these witnesses. The Court of Appeals then could take up that appeal ahead of a new trial because they have now sufficiently developed the record and the testimony so that the Court of Appeals can make a ruling on it simply because they now have enough facts for the court to consider.
With this mistrial, we know that there's also a civil case that's pending right now. Any impacts on that, if anything, that we might be able to expect down the road when this civil trial gets underway?
Well,
or civil case, I should say.
I also listened to Mr. Johnson's press conference yesterday.
There was a lot going on.
There was a lot going on, and he seemed to indicate that they are ready to go full steam ahead with the civil case. And he also mentioned something that I think is important for the viewers to understand, is that in the civil case, the burden of proof is much less. There are different legal issues being resolved in a civil case, and it's not proof beyond a reasonable doubt. So he was trying to indicate that we'll likely get a favorable verdict when we go forward with the civil case. But that comes back to the criminal case and the issues that the defense was raising, because they were saying by going into this officer created jeopardy or talking about, he shouldn't have done the foot chase. Actually, what they're arguing, in my estimation, is that they blurred the line between proof beyond a reasonable doubt in a criminal case and the civil standard, because those things may be appropriate in the civil case, the officer created jeopardy and things like that. So I think part of their argument is, look, you lessened the burden here by allowing all this civil kind of evidence into this case. So it's going to be really interesting going forward if Mr. Becker does decide to continue with prosecution.
This is an interesting thought, and I want to kind of ponder this for a second. So speaking between a trial case like this, a criminal case, and then a civil case, can you kind of explain the differences that we should expect to look at or maybe look forward to here? That way, just our audience can understand what the difference is here and how that's specifically applied to this case.
Well, they're different issues altogether. In the civil case, there's what are known as causes of action, and I'm sure that they would have filed those under what's known as violations of Mr. Loyola's civil rights, which is a separate statute. It's a federal statute. It's completely separate from state criminal law. And so in a civil case, we might call it excessive use of force or wrongful death. And the standards are completely different. The law is completely different. And that's in federal court versus in state court, where it's simply these are the two crimes that are alleged to have been committed. And so the jury in a civil case is going to consider completely different evidence than jurors in the criminal case. And so the public needs to understand that those are just two completely separate and distinct issues.
And that's where I think the blurred lines come in, because in the civil case, in many what we call tort or civil action type cases, the defendant's negligent conduct is relevant to the cause of action and any defenses that may be available. And so by allowing this idea of police created jeopardy to creep into the criminal case, they really were bringing that concept of, oh, we should have a different outcome because he was negligent. The defendant was negligent in how he acted according to the prosecution's theory. So I think there are some really interesting legal issues that can be challenged if this case continues.
Well, not to mention there's a constitutional thing going on here too, because you have a constitutional right to defend yourself, and the defense said this all along. Look, the officer doesn't have a higher standard in using lawful self-defense, which has been found to be constitutional under the Second Amendment, where when you get to the civil case, you lose a lot of those constitutional protections because it's not the government bringing the case, it's a private party bringing the case. And so that's a huge distinction that people need to understand.
Let's do a little hindsight 2020 with the time that we've got left here. A lot of the arguments that we heard, a lot of the testimony, Some witnesses on both sides did contradict themselves, and of course you kind of mentioned it off the top of our interview here that some of the testimony was a little confusing. Also, the voluntary manslaughter charge added on there was a little confusing as well, possibly for the jury if we're thinking about it from their perspective. What testimony stuck out to both of you that could have been confusing for a jury in this process?
Well, first of all, the two experts from the prosecution who contradicted the prosecution's own expert from Axon, who was the guy. I mean, he's literally the guy to testify about the taser and its functionality and its capabilities and how dangerous it is when it's in the hands of an untrained person. And then you had these other experts say that, well, it's not dangerous and he should have known that it's not dangerous. Meanwhile, everybody from the Grand Rapids Police Department testified that he was trained in, Officer Schurr was trained in just how dangerous these things are. And so if I'm a juror and I'm sitting there and I'm like, well, just how dangerous is this taser or stun gun? It's outside the realm of normal people's knowledge. It's a felony to possess one without training in a CPL in Michigan. So I don't understand. That to me was confusing. Like, how did you have these experts contradicting the actual person from Axon?
Mm-hmm. Tonya?
I agree with everything Andrew just said, and I hate to Monday morning quarterback other lawyers.
Sure.
Because, as we said, there's the case you prepare, the case you try, and the case you wish you would have tried. I think what's important for the jurors to understand is the lawyers themselves are going to be doing some reflection on how the case was presented for both sides and what they might do differently going forward. I'm
curious for you as somebody at Cooley Law School teaching law to students who are getting ready to be a lawyer in the future. How do you take a case like this and present that to your students as a teaching moment?
In a couple of different ways. I teach criminal law and I cover homicide and I also cover self-defense. And so I may very well bring in some of the facts from this case as a problem for my students to talk about. I also teach trial skills, and so there are some interesting things that happened in this trial that I can show students as they're developing their skills to go into the courtroom and handle cases themselves.
Yeah, and what about you? Anything to take away? Like if you're an attorney such as you guys watching this go on over the last week and a half?
I'll tell you this, it's really hard as a trial attorney to watch other trial attorneys because everyone has their own style.
They got their method to their madness.
Everyone
right?
has their own style. Everyone's got their own way to cook, and sometimes you just got to let them cook because they're good. I mean, they get good results. I mean, these were all very skilled trial attorneys on both sides, and so while we sit here and we Monday morning quarterback, we don't know what's going through their head as they're going through trial. We don't know what pitfalls they're trying to avoid, and so for us to sit here and comment on it after the fact is, it's kind of, in some level, there's some hubris going on our part by commenting on what they're doing.
Yeah. Any final thoughts from the trial over the last, well, I mean, it lasted 8-9 days. So any final thoughts and where this thing goes from here?
I am going to be watching very closely to see what happens. And if there is a decision by Mr. Becker to go forward with a second trial, I am going to be watching with great curiosity what the defense team does to challenge the charge and or the potential expert testimony.
I agree. I think that's the central issue in this case is what testimony should have been allowed and should not have been allowed.
Okay, and we'll just have to see. We appreciate you guys so much. I know you guys were on the air with us, I think, every day since this whole thing began. So we appreciate your time, and we'll certainly be watching.
Great.
All right, thank you guys. All right, it is 9:19. Of course, we have a special edition of On the Docket today talking about this trial and how we've decided to cover it. You can watch that on 13+. We also have each day of testimony pinned to the bottom of the screen right here in the app. So download on your TV and, of course, watch for free.